Welcome to CC Partners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.
Bear with us as some of these questions we are seeing for the first time and trying to adjust on the fly. So I apologize to my colleagues if you're being put on the spot, and I apologize to those of you watching or listening for anything that isn't quite as smooth as you would normally expect from us. So bear with me one moment while I get the screen up. Again, as I mentioned in the presentation, I am not destined for a future as a professional Zoom host, but I will do what I can to make this easier for all of us. It's not going to do it, but almost there. Sorry, everyone. It is coming, I promise.
Kelsey, while you're doing that,
yes.
There were a couple of questions in the queue about people who don't want to come back to work because of transit issues.
Yes.
And whether that is something that an employer can dismiss if employees refuse. So it's a bit of a tricky question because it's going to depend on the circumstances. Generally speaking, how an employee gets to work is not an employer's concern. Someone who chooses to take public transit as opposed to other forms of transportation, those are decisions that they make in most part for personal reasons. So I would say that unless the inability to attend at work or the reason for taking public transit is related to some form of disability, that the mere fact that they don't want to be on public transit is not a sufficient reason not to be attending at work, because they can pursue alternatives. They could try carpooling if that's available. They could bring their own vehicle in. They could be dropped off at work. So we would say that the mode of transportation is not a health and safety issue in of itself. And so we would not be recommending that you involve the Ministry of Labor if someone's refusing to work on that basis. But again, before taking a difficult position in terms of a job abandonment, we would encourage employers to try and come up with creative solutions for people like that. But it would not raise a specific health and safety concern, unless again, for some reason, being on public transit is part of your job. I'm trying to think of a job that would entail other than being a transit driver. So, and all the public transits, all the municipalities are doing their part with their transit workers as well, in terms of reducing the number of people that can be on the bus and how you get on the bus and whether you have to pay for bus services in a lot of municipalities. So.
Yes, I see Shauna there, quick to point out that Brampton Transit, as are I think probably all of the transit operators, doing their best to protect the public, the riders, and their employees, obviously. So I think you're right. And
hats off to Brampton Transit.
Okay, so I've got some Q&A coming up here, and I figured out how to do it. So let's move into that, and thank you, Susan, for taking that one on, because it was a question that we got. So this one I can handle, and I think we're going to learn more. Well, I know we're going to learn more in announcements coming out next week with respect to education, schools, and childcare. And when we're talking about PPE required in all emergency childcare centers already, is it a requirement when we reopen? We're going to find out. I mean, I can't see that it won't be to some extent. There are going to be protocols. There are going to be things that will have to happen that are different from what they normally had in and that's going to be true of every sector. You know, you think about food handling, that already is really highly regulated, and so, you know, there aren't as many changes for some of those highly regulated, or it's easier to adapt. But I think we're all going to be dealing with, as employers, the new normal, right? And from a childcare perspective specifically, you know, we all know that the economy can't really get going until childcare gets figured out, because so many people are limited in what they can do, even working from home with kids. You know, at least I say anecdotally. So it's going to be important, but we're going to learn in Ontario at least next week with some more. And I know there's already have been some guidelines put out with respect to potential expectations, and you know, I think the childcare sector is going to respond with what's reasonable and realistic to expect out of children of all ages as well, right? And so that's kind of, it's a tough one to answer right now, but I can't see that it will be just business as usual anywhere. So the next slide then. Take a minute to read it and see if any particular one of us want to tackle it.
I can tackle this one, Kelsey.
Thanks, Charles. Go ahead.
So in this case, where you say you have generally granted any COVID-related leave of absence requests received with no specific return date. So I believe those restrictions, like they can be tied to the length of the state of emergency or whatever. But in any event, what you have to look for is whether they continue to qualify under the legislation for the leave of absence, because the way that it's drafted is that if you meet the requirements for eligibility, you are entitled to the leave. So what I think they've tried to do, I don't want to speak for them, is they tried to tie it to orders to shut down. So if you can't be business can't be in operation, then we have these leaves of absence to protect employees so that they can maintain their employment while they aren't able to work. So you have to look at the specific leave that they're entitled to see what it's limited by. But if they fail to meet the eligibility requirements, or the leave no longer applies because there's a shutdown pursuant to some order, then you would have the right to call them back. What you'd want to do in that situation, and really any situation, I think a lot of the answer to a lot of these questions, because we don't have the answers that we want, is really just try to be as reasonable as possible. If you're going to make a decision that you might find yourself in front of an arbitrator or in front of an employment standards officer, where you're trying to basically justify what it is that you've done, you want to be able to say that you've given lots of notice. So to the extent that you can give a week, 2 weeks notice that a leave of absence is going to come to an end, you should be trying to do that as much as possible. It may not always be possible, but the government's been pretty good about giving some time lag in the lead up to announcements. So they'll make an announcement on Monday for an opening on the following Monday. So as long as you're providing notice, doing that kind of thing, and then going back and checking to make sure that they don't still qualify for the leave, despite the fact that you are opening, then you do have the right to recall them back to work. Another question I've been getting is some employers are trying to do the right thing. Sometimes they'll grant leave of absence just out of hand because employee's got a problem. So if you've granted what I would call a gratuitous leave of absence, that's not necessarily linked to something in the ESA, and the employee doesn't qualify for the ESA, same kind of considerations. You do have the right to call them back because the terms of the leave of absence are basically dictated by the employer, but you want to give as much notice as you can. And that kind of thing, and just make sure that whenever you're going to call people back, take them off leave of absence, whatever it may be, you want to be as reasonable as possible and provide as much notice as possible.
Thanks, Charles. Let's see what our next one is here. It's a couple interrelated ones. So if an employee has traditionally worked a 35-hour week, but upon reopening is working reduced hours, if we ask them to work less and they refuse, what can the employer do? And if we're not, do we have to bring people back to their full salaries? Like, these things are related, and questions we certainly get all the time. And this goes, kind of to the whole constructive dismissal aspect. And Susan, if you're comfortable with it, because I know you addressed it briefly in terms of what we've learned from COVID-19, if you want to take this one, that'd be great, and just kind of re-emphasize what employers are facing. Oops.
Absolutely. So you can bring people back to work on reduced hours as long as you don't trigger, as Kelsey said, a constructive dismissal. A constructive dismissal is a unilateral change to the terms and conditions of employment, to a fundamental term and condition of employment. Compensation is a fundamental term, and it has to be a significant change. And so the courts, in normal times, the courts would say a 10 to 12% reduction in compensation will not trigger a constructive dismissal. Anything past that will. So, those are sort of the guidelines that we use generally. I would say that during this time period, given that the federal government has created the wage subsidy, which is a 75% subsidy, that a 25% reduction would probably not trigger constructive dismissal, particularly if you were only bringing them back at that on those reduced hours for a certain period of time. So again, it's going to depend on how many hours they're being reduced and for how long. And those, unfortunately, we can only deal with on a sort of case-by-case basis. But no, you do not have to bring them back to their full-time hours. If you can't afford to, you just will have to be able to justify that you can't do so. So I think that answers both of those.
It does. Thank you, Susan. Next question then we have is a recall question. So probably me, since I dealt with the recall. What happens if an employee wants to return but has childcare obligation and wants to work at odd hours, so outside of office hours? Based on their duties, that won't work for the company, and they're required to be in the office with respect to the the company's these operational needs, right? Do we have to? And so this this really brings in a whole host of issues, not just the employer's right, but also going back to, if you recall, the last bullet point on my second slide about recall is how do I retain key employees? Well, if this is a key employee, you've got to think about, okay, well, can we be flexible at all? If they've been on serve this whole time because they cannot work outside the office, then that's pretty clear that there may not be a lot of flexibility around that. If you're asking, though, do you have to recall them, or is it legally or morally your duty to recall them so that they're not just freeloading on serve when they should otherwise be at work? That's technically, you probably, from an employment perspective, you do what you need to do from an operational needs basis, right? And I think it's a consideration for everyone, and probably a specific question to deal with your advisors, lawyers, and accounting professionals. But I mean, for that employee, when receiving the CERB, they've got to, essentially say that they're entitled to it. They've got to attest to the fact that they haven't voluntarily quit. If they've got these childcare obligations, then their job's protected, right? At least in Ontario, under the Employment Standards Amendments. If you're talking about trying to work something out and you need to do it, there are a whole host of things that might come into this. If it's just that they don't want to come back, or they want to work flexible hours and it doesn't work, then that's a different story. But if it is literally the childcare obligations, then we talked about that. And I apologize for kind of skipping forward, but those in Ontario are a specific ground of protection, right? So like we said, if they don't figure out the childcare thing and a way to do it safely, then the economy is in general going to have a hard time ramping up to full capacity at any rapid rate. Susan, I think you wanted to interject there.
Yeah, no, I think you're right, Kelsey, that, you can't take a job abandonment position in these circumstances. But as the employer, if the employee can't fulfill the essential duties of their position, and that's the position that they're hired for, then you don't have to bring them back if you can't bring them back to doing what they were doing before. So based on their duties, if most of their duties have to be done in the office, then we would take the position that despite the childcare obligations, if they can't come back in, they can stay on CERB, they can stay on their job protected leave, but the employer does not have a positive obligation to bring them back to something that looks totally different than what they had prior to going off on the leave. So I hope that answers the question. I don't think you have to accommodate them to the extent that you basically give them a different job. That would not be required under either human rights legislation or the Employment Standards Act. But there may be as well, and we've had this situation in our own office, there may be other things that you can do on a temporary basis to give them some relief from their childcare obligations. And we would also really be pursuing what in fact the obligations are. Is this a personal preference? Right now, obviously it's not because daycares are not open, but probing the employee as well as to whether or not there are obligations or preferences, because those are treated very differently in terms of your duty to accommodate.
Yes, thank you, Susan. A lot of nuances to that question depending on where it's coming from and what the requirements are. So the next one, employees are reluctant to return but don't fit any of the protected reasons, citing anxiety and fear. Rather than job abandonment or STD and LTD with doctor's notes, is that appropriate? Well, I mean, anytime there's medical information, right, I think you've got to act on that the way you normally would as a responsible employer, and that's finding out what the restrictions are, what the prognosis is, all that kind of thing. And to the extent that you as the employer are willing to accept those things at face value, which, this is not to say that these things aren't valid, but it's also a balance of the competing interests of the operational needs and the medical needs and restrictions of employees. So, I don't think it's, I wouldn't say that it's not appropriate, which is a strange way of saying it, but I think it's all going to depend on what you're looking for and what the nature of that medical information is. And if you're asking whether you can challenge it, I think that'll depend on the certain specific circumstances.
But I do think that if you have STD and LTD and they otherwise qualify for it, and hopefully you don't make those decisions, your insurer makes those, then I think it would be appropriate for them to go on short-term disability and long-term disability. I would not be claiming a job abandonment for these individuals if they would qualify for other disability plans within the organization.
Yeah, certainly. If they're independently qualifying for those specific plans, absolutely. I think you're right about that. I'm thinking more in a general sense of, the cynical employer view of, well, you can get a doctor's note for anything pretty easily these days, right? And then that's a matter of, okay, well, what are you willing to live with? What do you want to see come out of it, and what do you need, right? And that goes again back. So leaving aside the STD and LTD programs and actual qualification for you as an employer managing these things, it's what serves your operational needs better. Forcing someone who doesn't want to be there, or working around them in another way, or managing a gradual return so that people can be more comfortable with this, quote unquote, new normal. Okay, so an employee is on sick leave due to injury outside of the workplace. They provide group counseling, and they've been temporarily replaced because that position wouldn't be able to do the group work. The union is saying you have to fill the position during the employee's sick leave, regardless of the fact that the job can't be done. This one might be a little too specific. I see Charles has unmuted himself. What are your thoughts here, Charles?
Yeah, so these ones are tricky. Basically, anytime you have a union involved, because obviously there's going to be collective agreement language that comes to bear on this. So really the answer is going to depend on the particular wording of the collective agreement. But so leaving that aside, in general, I can say it would be kind of strange to force an employer to fill a role where the work can't even be done. That being said, because you have a collective agreement, which tends to be quite detailed, you may have to take some technical steps in order to avoid that. So, for example, some collective agreements will say that any job vacancy has to be posted for the bargaining unit within a certain amount of time, and then even some others will go further and say it has to be filled within a certain amount of time. If that's the case, you have to remember that unless there's clear language in the agreement, it's the employer who decides whether there's a vacancy or not. So in this case, if you had someone off on sick leave and then the pandemic hits, then that person's job is not able to do it, then even if you had posted fill language, then there may be an argument to say that, well, there is no vacancy because the work's not being done. And again, that's going to depend on the language. The other thing you might have to do is, if you have post and fill, you might have to take the official step, take the paper trail of eliminating the position. Although you'd have to look at other language because that often comes with consequences, notice consequences, or payment consequences for now. And then when things start to become normal again and this work does start to be getting done, then you would create the position again. But all that comes with the caveat that you would need to look at all the language at play because there could be certain consequences. So I'm not suggesting that necessarily as a course that you take in this situation. But obviously, if you wanted more detail about your specific situation, you'd be happy to take it offline. But in general, it'd be strange to have to fill a position where the work is not being done. It's just a matter of what the appropriate response is and if there are any technical steps that you have to take based on the language of the agreement.
Yeah, so I think the short answer there is give Charles a call, and he can help you with that. Okay, so let's see what that may be the last one that we got to. It is. So I saw one come in at the end that's talking about an employee who has been terminated, whose employment has been terminated. They were laid off, but they're not responding to any attempts to discuss. Obviously, that brings with it some different considerations, but the specific question was about the statute of limitations. And Charles, I know you addressed earlier how all the adjudicative bodies are functioning or not during the time. What can you tell everybody about statute of limitations and limitation periods generally? I'm sorry to put you on the spot like that.
Yeah, no problem. So this goes back to what I talked about before, the order under the Emergency Management and Civil Protection Act, suspending limitation periods and time periods for any process or time period under an adjudicative body. So limitation periods, you remember I said that the time limits are up to the discretion of the body. The limitation periods, there is no discretion. So in general, and this applies to most employment disputes, so if you have an employment standards complaint that you're going to go to an employment standards officer, I think the limitation period is 1 year on that. So basically, if the dispute arises from March 16th to the end of the state of emergency, then the limitation period is going to run from the end of the state of emergency as opposed to the date that the complaint arose. And the same thing for like a wrongful dismissal complaint, except the limitation period there is 2 years. So anything that happens if the complaint, dispute, violation, whatever arises during the term of the state of emergency, then you're basically just going to take the date that it happens, move it to the date that the state of emergency is lifted, and your limitation period, whether it's 1 year, 2 years, 1 year also for the Human Rights Tribunal, it's going to run from that date as opposed to the date when it actually arose.
Excellent. So thank you, Charles. Thank you, Susan. And thank you most of all to all of you who have tuned in, joined us today, and our numbers have dropped off as people needed to get things done. If you're like me, this would be the time where normally my kids are clamoring for some food. So we get it, believe us. But, we had an excellent discussion today. I appreciate all the questions coming in, and really enjoy doing this with everyone and being able to share information and knowledge to the extent that we have it. And the general discussions are always good to have. So just leaving you with the last few thoughts. We've said, it's all about asking questions when people are coming back to work and making sure that you as the employer are doing the right things, right? So you can demonstrate that you have taken every step necessary to protect employees, so that if they're not willing to come back, you know what to do next. We will see things change, I'm sure, in the coming weeks and months, if not days. But in the meantime, stay tuned to our blog, our website, our Twitter account, all of those things where you can find the latest information. And feel free to contact anyone of us directly or anybody else at CC Partners. We're here to help you. And, despite the fact that we're working remotely, or possibly because of the fact that we're working remotely, we are just as accessible or more accessible than we've ever been. Thank you, everyone, and have a great day and enjoy your long weekends.
Get to know us better at ccpartners.ca.